Moving on to item D, presentation and discussion of newly enacted state statutes and Oklahoma Department of Health rules governing the sale and regulation of medical marijuana following passage of State Question 788. And Trevor gets the joy of presenting this one.
Thank you, Vice Mayor Udi and Council. As you know, in June of 2018, Oklahoma voters passed State Question 788, legalizing medical marijuana within the state of Oklahoma. Several things have occurred as a result of that vote. The first is the Oklahoma Department of Health was charged with drafting regulations to implement this state question. Their first attempt and draft was adopted in July. It was about 75 pages. You might have seen in the news there was a lot of concern over overregulation, things such as restricting the sale of smokable marijuana, requiring pharmacists in each of the dispensaries, and setbacks from churches, things of that nature. As a result of those concerns, there was a revision, and on August the 1st, 20 pages of regulations were adopted by the Health Commission that were actually signed by the governor yesterday. So this is a rapidly evolving area of law. Tonight, I'm not going to try to go through all the regulations and rules. I just wanted to educate the council on some of the issues that will be facing the city in the very near future and set out a timeline for that. So before we get to the slides, what I want to note in terms of timing. The Department of Health is supposed to accept applications for medical marijuana license holders, those who can use medical marijuana, also for their caregivers, for dispensaries, that's where the marijuana would be sold. For the commercial growers, that's where the marijuana would be growed, which would be sold to the dispensaries for sending out to license holders, and also for processors. Those are folks who would process marijuana into edibles and things of that nature. The deadline is August 25th, 2018. For the Department of Health to accept applications, and they should begin to issue licenses by September 8th of 2018. So this is coming upon us very shortly. With that in mind, on August the 30th of 2018, a special Planning Commission meeting has been scheduled. And at that meeting, Development Services has proposed and has drafted some zoning recommendations to address where the medical marijuana dispensary should be located within the city of Broken Arrow zoning. One of the issues of 788 was that cities and other municipalities cannot opt out of 788, meaning it's not an option to have a blanket prohibition on medical marijuana dispensaries. So by law, they're going to be allowed. The only issue for us to decide is where would they be zoned and what does it make sense in terms of where they should be located. And Development Services has worked on that issue along with the legal department, and those recommendations are going to be considered by Planning Commission on August the 30th. Before then, on August 21st, City Council will meet again, where I will have a preview ordinance that would govern the permitting process for medical marijuana dispensaries and also potentially for growers and processors. And that'll give the council an opportunity to look at some different options in terms of regulating the permitting process of what we want for the applications. What do we need to know about, and also manual fees, what types of fees that we'd like to charge, things of that nature. And then on September 4th, following the special Planning Commission meeting on the 30th, council will be able to review for final adoption the permitting process ordinance and also consider the Planning Commission's recommendations on locations for the dispensaries and potentially for processors and growers. So with that timeline in mind and kind of as an outline, a map of where we're going, I wanted to get a little bit into the law just so everyone can be fluent in what we're talking about of what we'd be regulating. So what exactly does medical marijuana do? So let's see, I'm actually at the very end. Can you bring me all the way to the beginning, to give me my first slide? There we are. So first we have to start with the medical marijuana license holder. So under the law that was passed, basically a person who's issued a valid medical marijuana license can consume marijuana legally. They can possess up to 3 ounces of marijuana on their person. They can grow 6 mature marijuana plants, have 6 seedlings, have 1 ounce of concentrated marijuana, and then possess 72 ounces of edible marijuana, and possess up to 8 ounces of marijuana in their residence. I'd like to provide a caveat and say that marijuana is still illegal under federal law, and this state law question does not change the status of marijuana being illegal under federal law, and we are not impeding or keeping the federal government from enforcing the federal law that prohibits it. However, what we are required to do under the state question 788 is to enact ordinances in compliance with 788. So the first step in the process is those who need medical marijuana, they go to the Department of Health, they get a license, and that's what they're allowed to do with the license. There's also provision for a caregiver's license. Basically, if someone is a medical marijuana license holder and they're homebound, they can't get to a dispensary to purchase their marijuana, they can have a caregiver go to the Department of Health and apply for a license and get a medical marijuana caregiver's license. And that gives them the rights as a medical marijuana license holder. They're not using it, they're obtaining the marijuana to give to a licensed holder. And so, as I mentioned, marijuana is still illegal under federal law, but obviously there have to be changes to state law if we're going to allow medical marijuana. And specifically, what the state has done is they've made the possession of up to 1.5 ounces of marijuana by persons who can state a medical condition, but they don't have a state-issued medical marijuana license. Basically, it's a misdemeanor offense, and that can only be fined $400. So the statutory regulation is basically, if you have a medical marijuana license, it's legal for you to have all those types of marijuana I showed you on the last slide. However, if you've not gone through the process to get a license and you still have 1.5 ounces of marijuana or less, you won't be arrested for that. It's a $400 fine, and that's all you can do under the state law. In addition, all of the paraphernalia rules have had to be rewritten under the state question 788. No device that's used for the consumption of marijuana, for medical marijuana, can be declared illegal. And you'll see later on the agenda, there's 2 preview ordinances that reflect those changes. The first ordinance will reflect the change of the possession of marijuana if they state medical condition and they have 1.5 ounces. It reflects a fine of $400, and it also repeals the paraphernalia restriction for medical marijuana. It does still keep a Class A misdemeanor offense if you have marijuana and you can't state a medical condition and you don't have your license. So the process to license medical marijuana was developed by the Oklahoma Medical Marijuana Authority. That was created by the Oklahoma Department of Health. As you can see, this is one of their forms here for a physician recommendation form. So one of the requirements for a medical marijuana licensee is they have to get a recommendation. It's not a prescription because marijuana can't be prescribed. It's not recognized as an medicinal drug by the federal government. It's still labeled as a Schedule I, meaning it has no medical use or purpose according to the federal government. So a doctor can't prescribe it. So what they do is they'll make a recommendation, and this is the form that they'll use to make the recommendation. As I talked about, there at the bottom, there's a certificate of necessity of the caregiver. So that's the caregiver license process that I discussed previously. Once the form is completed, there's an online process. It's not even in paper. You have to go to the online portal that they have and fill out your application. It's a $100 fee. They have to submit their recommendation form along with the fee, and then the Marijuana Authority has 2 weeks to process the application, and they either have to accept it or deny it. So those are the licensees. So those are the folks who actually will have the marijuana and are using it. And the second question then comes about, well, how will medical marijuana users actually obtain their marijuana? So one of the options that we talked about on the first slide was they could actually grow the marijuana themselves. They're allowed to have 6 plants in their own home if they have a license. So that's one option. The second option would be to purchase it from a medical marijuana dispensary. The dispensary licenses are also processed by the Department of Health. There's a $2,500 application fee. Those applications will also be accepted on August the 25th. The Department of Health has 2 weeks to approve or reject those applications. And that's the process that they've adopted. The only real restrictions that the Department of Health has on the location of dispensaries at this time is you cannot have a dispensary located, the entrance of a dispensary located within 1,000 feet of a public or private school. And so I know Development Services is looking at creating a map to show on the recommended zoning where that would actually be located, considering the number of schools that we have. And so that is the only restriction that they really have on the locations for dispensaries. The next category that potentially could be in the city are medical marijuana commercial growers. So the dispensary license does not allow the dispensary to actually grow the marijuana. It allows them as a point of sale for the retail sale. They have to obtain it from a licensed commercial grower. Commercial grower applications are also set up through the Department of Health. Those applications will be accepted on August the 25th. Licenses could be issued as early as September the 8th. The Department of Health has several pages of regulations in terms of how the growers can operate. It's notable under the law that there is no restriction on the amount of marijuana a commercial grower can grow. So there's absolutely no limit. Also, there's no limit on the number of commercial growers or dispensaries that can be located within the state. There's absolutely no restrictions or legislation on that. It's these types of issues that have made a lot of folks call for a legislative special session to have specific rules and regulations. As you can imagine, most of the communities who have instituted medical marijuana have thick regulatory books. Right now, Oklahoma has a 20-page slim volume. So I do expect this to be a rapidly evolving and growing area of law with further regulations. One thing of note is that under State Question 788, municipalities cannot unduly restrict the locations of medical marijuana dispensaries. There's no similar language for commercial growers. As such, it would be a choice for council to decide whether or not they want commercial growers to be allowed within the city, or potentially not to be in the city, or to have a compromise on where they would be located. So that will be one issue that will need to be decided both at the Planning Commission and by council. The same holds true for the marijuana processing licensees. Again, that's more of an industrial, my understanding is more of an industrial type program where they would create things that are called edibles. Those are candies or cookies or other types of goods that you consume that are infused with the active ingredient of marijuana, which is THC. Along with the other licensing requirements is a transportation license. Obviously, folks will have to transport the marijuana from the commercial grower to the dispensary for then distribution. Those are also regulated by the Department of Health. And as I alluded to, the zoning issues are really what we're going to have to be faced with in terms of where are we going to allow the medical marijuana dispensaries. As I said, the specific law under Title 63, Section 423AF restricts the municipality from unduly changing or restricting zoning laws to prevent the opening of a retail marijuana establishment. And then again, the only specific restriction on their locations found in the law was a 1,000-foot restriction for public and private school entrances. And then obviously taxation is also an issue that will have to be addressed. So if you read the language of State Question 788, it has a specific provision about a 7%, what they call a sales tax. And so there's been a lot of questions of, well, is that the only tax that will be collected? Will cities and municipalities be able to collect their sales tax? Unfortunately, the Oklahoma Tax Commission will be regulating and collecting this, and they've not issued an official position. They have made statements from their spokesperson, and this is what I've gathered from the news media. Basically, what their spokesperson has said is that since there's not been a specific statute that exempts medical marijuana from the collection of sales tax, that the sales tax will be collected. So the way to look at it would be, there'd be the 7%, which the Tax Commission is considering as an excise tax, similar to what it would be collected on a liquor store. And in addition, on top of that 7% excise tax, which is specifically designated for funding the marijuana regulatory agency, you'd be able to collect the local regular sales tax, which is approximately 8% and a little bit more, I think. So you'll have an effective sales tax rate of approximately 16% for the medical marijuana. There is some question about the wholesale level. The taxes are only specifically for the point of sale for the dispensaries. So I need a little bit more guidance from the tax commission on whether or not the commercial growers or processors would be subject to any sales taxes. With that, I'd entertain any questions that you might have. As I said, there is little regulation of this at this point, and I know a lot of cities are struggling with how to implement this law. And so I think I'd like to give a lot of credit and recognition to Mr. Skates and Mr. Curtis in Development Services. They've really taken a lot of effort in developing potential solutions on the zoning issues.
So, let me start. And I know we can't put the feathers back in the pillow, but I've got a number of concerns. Number one is I look at Oregon, who is producing 5 times the amount of marijuana that they have consumption. So what's going to happen with all that? I mean, they're not going to just grow it and throw it away. So that's one. We can't limit the number of dispensaries, but can we limit both the location and the zoning where they go? Like they'd have to go in industrial? Because I can tell you, I represent 2 property owners that have already been approached about growers. I've cautioned them that this is going to be something that likely will have a lot of bankruptcies. So I certainly told them to go in a different direction. The other is I noticed that one of the state requirements is that they get their prescription from physicians, though the actual law says board certified physicians. My brother's been a physician for 45 years, is not board certified. So does that mean when the police stop somebody and they have a certificate, we just going to let them pass, or do they have to show proof that it was a board certified physician? Is there a quantity of the marijuana that a producer can grow, and how do they account for that quantity? And I think that's all my questions right now.
Sure, and I'll do my best if I may take those in order.
Sure.
I do have a little bit of information.
Okay.
I don't think I can answer all your questions satisfactory. We just don't have enough information. I think your concern about Oregon is well taken. They've found that a lot of their marijuana is being flooded onto the black market, so it's like you said, you can't put the feathers back in the pillowcase once it's out there. I think that one of the ways the Department of Health will try to prevent the leakage of the plants or the marijuana onto the black market for recreational use is inspections. There's provisions for inspections and auditing and accounting for the amount of marijuana that's being grown, and all that's done at the state level.
So do we have control of who has a license, and can we require licenses for growers so we know who's growing?
So we don't control the licensing at the state level. So in order to have a dispensary, a commercial grower, or a processor, or to be a medical marijuana user, you have to get a license at the state level. What we can control is issuing permits on who can have a dispensary or a permit for the grower or processor, and make sure that they comply with their zoning requirements. In terms of limiting the number of dispensaries, like I said, I don't believe that we can, under the law as it's written, we can have reasonable and due restrictions on where it's located, and that's what Development Services is working on. So we can't outright ban it. We also would be prohibited from exacting zoning regulations, which would have the effect of having an outright ban on the dispensaries. I don't believe that also applies to the processors or the commercial growers. I believe that we would have the opportunity to not allow that to be zoned in the city.
I presume we can limit because since this is retail activity, the dispensing of these drugs, since this is retail activity, we could limit it to retail locations. We don't have to permit someone to open a dispensary out of their house, I would presume.
Sure, absolutely. We can have, in my conversations with the development services is focused on where does it make sense, how does it make sense to treat a dispensary. Some analogies have been pharmacies, some analogies have been liquor stores, some analyses, depending on how you want to look at it, could be, as a Walgreens. So those are all the things that they're looking at. So yes, we certainly can designate where it would be located. In terms of your third question, Councilmember Lester, about recommendation from physicians, that'll be controlled by the Department of Health. So the form.
There's going to be our police officers that are the ones that are front line.
And it'll be a card. I think it'll be a card. I've not actually seen what the department's going to issue, but if you looked at the slide that I'd had for the physician, if you could. That's the form the physician will fill out, and that form will not be carried by the patient. That form will reside with the Department of Health, and so the Department of Health will actually issue, I assume, would be something like a driver's license, similar to that, to each medical marijuana license holder. So that's what they would have to show our law enforcement officers. We just would have to trust the Department of Health that they've enforced the regulations.
Sure, let's go with that.
And then your last question about the quantity of marijuana grown. A commercial grower, according to the specific language of State Question 788, there's no limit on the amount of marijuana they can grow. And that's what the language said, and that's what was voted on by the people. And how do they account for it? The Department of Health, I believe, at least my understanding of their regulations, should be doing audits and should be, like I said, they went from 75 pages of regulations to 20. In the initial version, they had to have testing, potency testing, making sure that it was within range limits for THC. All those were done away with the 20-page regulations. And my understanding, it was partly at the recommendation of the Attorney General about whether or not the Department of Health actually had the power or ability to make some of these rules and regulations. And again, that's why the call for the special session has been made, so that we can have some more guidance or clear guidance on how these were going to work.
I've been reading that it is going back, and the legislature can make changes. So some of the things you mentioned tonight could be changed, even the zoning application and whatever, where it can be, the legislature can come in and make changes to what we've been talking about tonight. Is that correct?
Yeah, absolutely. And like I said, this is a rapidly evolving area of law. It's not been fully regulated at the state level. We need some guidance.
A big concern of mine is things like it's pretty easy to test for if someone is inebriated by alcohol, but if they're operating a motor vehicle or equipment under the influence of this type of substance, how do we test for that? What kind of training are we having to give our police officers and to deal with this? This is broader than just zoning. How much money are we having to spend to implement this project? The statute.
Those are all great questions. In terms of testing drivers, you're probably familiar with the intoxilizer. That's what you'd think of when someone is pulled over for DUI and when they have to blow into the there's not a similar device, for marijuana. You can do blood testing to determine THC levels.
Doesn't that require a reasonably so, because of constitutional protection, but doesn't that require a warrant or something like that would basically, this is what's concerning me, is you have people who are operating vehicles with this in their system.
Sure, and I believe it'll be a continuing challenge, as it has in law enforcement that has legalized medical marijuana. One of the options, obviously, we have drug driving laws. You could be under the influence of a prescription drug. You could be under the influence of enough NyQuil, so to speak. And so we can rely upon the observations of our officers in the field as well. But I agree with you, Vice Mayor. It's a challenge, and I don't know if we have a good answer for you. And I think that's something we'll have to work closely with our law enforcement to come up with some solutions.
Well, and I think with what Mike was saying on the commercial properties, since it is federally legal to sell marijuana, you probably won't even get title insurance because you can't get that on the properties where people are wanting to come in and buy these buildings to sell and grow and all of that. And, yeah.
Well,
Very good point.
Plus, the banks cannot accept the money,
Right.
so that means they're going to be more subject
Mhm.
to armed robbery because of the large sum of money.
Yes, research I've done, it's usually a cash business.
Right.
They can't even take checks. The banks don't want to get involved in accepting the money because they could lose their charters. And so that's another concern in terms of, where these are located. California's experience is they'd had issues with folks congregating and, like you said, robbing some of these places.
Right.
So those are concerns.
I also, does our sovereign immunity extend to defending, this is still illegal under federal law, and we're facilitating this, essentially, we're acting as facilitating the sale of an illegal substance under federal law. Does our immunity extend to protect the city from that kind of litigation or legal threat?
No, that's a great question. From the research that I'd done on this and what's considered by the council's action is we're not facilitating or telling people to do this. Okay, we're engaged in zoning and land use restrictions. So one of the caveats that I've drafted that I've seen and what other cities have done is this, and this helps. And it basically says nothing in this ordinance is intended to permit or assist in the violation of either the Federal Controlled Substances Act or Oklahoma's Uniform Controlled Dangerous Substances Act. Furthermore, nothing in this ordinance is intended to prevent or frustrate federal and state enforcement of any laws or regulations applicable to the possession, use, or distribution of marijuana, or act as a defense to the commission of any act prohibited by federal or state law. So I've not seen any city council or state legislature or any other governing body be indicted federally for putting in zoning regulations in accordance with a state question for medical marijuana. But it's a point well taken, and as an attorney, you probably appreciate this is an area fraught for practitioners to give advice to anybody because it is illegal under federal law, and we obviously can't advise people to break
The
the
Oklahoma
law.
Bar Association is recommending that its members contact their malpractice insurance providers to verify that they are giving proper. It has a lot of, I think, unintended consequences. I think the final thing I had is I had envisions, and this is what worries me, is I'm taking my children and wife out to dinner in, for example, the Rose District, and people are sitting on the sides of the street smoking marijuana, and I've got to try to figure out how I don't let my 9-year-old get a contact high. Can we still regulate smoking in public and things like that? Is that something we're still able to do for health purposes? So that does that make sense?
It does make sense. And so the guidance that I've seen on this is we already have a state law that governs the use of tobacco in public places. And that prohibits basically indoor smoking. It also allows, businesses to also ban, smoking. One thing that the current, and it's been my understanding from the Department of Health is they will enforce the use of smokable marijuana as they would for tobacco. So all the provisions that we have for the use of tobacco would apply to marijuana users. One thing that's not clear to me, though, is there is no ban on the use of tobacco in parks. There is no ban on use of tobacco on a public street. I don't see at this point any state law that would then prohibit the use of a medical marijuana user in public. I'm not saying that that's going to be allowed. It's an area that we need further guidance from and maybe some more work from. But what I can tell you is the marijuana would be subject to the smoking in public law for tobacco and may be subject to additional restrictions for the health and safety of our population.
Tell that to my 9-year-old when she's craving Cheetos. Are there any other questions?
Oh, so many.
Are there any questions
A
tonight?
good job of answering, you know
Yes,
what I mean?
thank you,
It's
thank
falling
you.
out, but
Yeah.
I just see so many changes to it, you know what I mean? It's just gonna be a work in progress, as you say.
I agree, and I think that's why you've not seen really any community attempt to have a cohesive regulatory scheme yet. They're working through it. You know, they're waiting, I think, for additional guidance. Again, the governor only yesterday signed the final rules for the Department of Health, who's supposed to be taking these applications by the 25th. So everything is kind of on fast forward, and you know, when we do that, things can sometimes fall through the cracks.
Any other questions? Well, thanks, Trevor. It was expansive. I knew it would be an interesting discussion.